He'll just kind of do a little run
He
around.
knows what he's doing. I know.
Couple minutes and then
Okay.
he's out of here.
All right.
All right,
He's a
so,
social media guru.
so we talked about a will, we talked about a trust, and now the next two documents in our essential six are power of attorney for finance, power of attorney for healthcare. These two simple, little, inexpensive documents are worth their weight in gold. So the power of attorney of finance is called power of attorney for property here in Illinois, is you, when you're competent and healthy, decide who you would trust to manage everything for you if you were no longer competent and healthy. And you do a power of attorney for property, that's everything financial and not just your bank account. Some people say to me, I put my daughter on my bank account, I don't need it. Oh Lord, there are so many phone calls. She can't even get you a cell phone or talk to your cell phone provider without them wanting you to get on the phone. Social Security, there are every single thing that you do of a day, someone is going to step in and help you with it. So for your power of attorney for finance, you want it durable, you want it, in accordance with your state law, and you're going to name the person that would be that you would most trust to take care of matters for you, and then you would name a backup for them. And again, when I see DIY estate planning, that's something I often see missing is backup. So, and contact information too, at least a phone number in there. So, and we've had police officers come to our office, one of our seniors, no longer independent, and then we use those numbers to contact people, family members, in other states. So contact information. And in those documents, you can determine everything that you want them to be in charge of. So everything financial, and then healthcare. Healthcare is super important, and if you already have a healthcare in place and it's really old, like from before the early 2000s, you might not have HIPAA. HIPAA is really important. Anybody who works in the medical profession in any way will have heard HIPAA. In the early 2000s, when it became really easy to disseminate information, come on in. Yeah, come on in. Sit back down again. It became so easy to disseminate our information with the electronic means that doctors' offices were just being a bit too free with our information. So the pendulum has kind of swung the other way with the HIPAA laws now, which means that you must give permission for anyone to get any of your private protected healthcare information. So we have situations where someone has an old healthcare power or wasn't drafted using HIPAA law, and they have given a family member authority to make healthcare decisions for them, but they're not allowed to get any of the healthcare information. So it really is a nonsense that can occur and just kind of tie people in knots. So make sure you have a good, durable power of attorney for healthcare, backup in it, and that you have HIPAA included with it. And in your power of attorney for healthcare, you get to make, amongst other things, your end of life decisions. Now, I don't say that everybody should have a living will, an end of life decision made in their estate plan, but if you know that you would not want to stay alive on life support, if doctors had determined that you were not coming back, that it was just delaying your death, if you would want to go, if you would want to die naturally with just comfort care, get that into your estate plan, and that's called a living will. So we make a decision in the healthcare power, and then we accompany it by a living will. And in the healthcare power, you say to your family, I don't want to be kept alive that way. In the living will, you take the decision out of their hands. And I will tell you, from sitting with people for 20 years, I have seen someone with tears in their eyes many, many, many years later, after having had to make the decision when a machine was turned off for a loved one, for a parent, that they say they never want their children to have to do that for them. So if you know that you would not want to be kept alive that way, get a living will and guide your children to what you would want in your power of attorney for healthcare. So, and it's those two documents, as we mentioned earlier, that keep you out of guardianship court. And guardianship court is so invasive that it is to be avoided at all costs. And I have seen, we've all heard of the sandwich generation. I mean, up until my parents died just a couple of years ago, was very, very much in that generation where we delayed our childbearing, we had younger children, we have very elderly parents, were trying to take care of everything at the same time. I had siblings who took care of my parents. There are many who are taking care of their parents, maybe their teenage children at the same time. They're already almost at breaking point. And if they now have to go to a judge for every penny that they need to spend, for every healthcare decision that needs to be made, that is, in my opinion, cruel. So these powers of attorney are a great gift to yourself. They're probably an even greater gift to those whom you love and that you know would take care of you. So now we got the will, the trust, power of attorney for finance, power of attorney for healthcare, living will, your end of life instructions. So that's just 5. So what's number 6? So number 6 is not a legal document at all, but it's one that I highly encourage all my clients to do, and that is a legacy letter. So a legacy letter is where you leave your wisdom as well as your wealth. And legacy letters are based on this ancient tradition. There are references to ethical wills in the Hammurabi Code, which predates the Bible. So that's how old this tradition of leaving the wisdom that you have gained or how you would want your family to spend your wealth, that's how old that is. And it was for many years and is still very much strong in the Jewish tradition, but now it's gone beyond the Jewish tradition. It's in the secular world in all religions. And I think it goes so well with my practice that here you've gone through the hard questions, you've planned for your family, you've planned for your disability, you've planned for after death, you've decided who's getting what. And I hear a lot of stories when you're telling me that. I mean, you kind of need to unfold through stories. So I've learned a lot about you, but that always gets left on the shelf. And I don't think it should do. So I encourage you to write a legacy letter. And because I love this so much, for years now I've been developing this program, tutorials, as well as a workbook and an online workbook. And in this, I just go through how to write a 20-page letter. So it's not a big, personal history or a full memoir. If you want to do that, wonderful. Do this first, because often this doesn't even get done or finished. So I say finish your legacy letter, and then by all means you can flesh it out later. So we just go through how to dedicate it, how to open it, how to write your first paragraph, how to set yourself in time and space, who was president, that sort of thing. 3 meaningful memories from your journey. It could be childhood, middle years, later years, vacations, how you spent your Christmases, your pets, your friends. And when you remember, when you feel something strongly from your childhood, there's usually a reason. It was maybe you were learning something. So all of these stories tend to carry messages. And then the next session I have you write about is the really hard things you went through. And this is the hardest piece to write. We have a lot of tears when people are writing this, but I say, what difficult thing did you go through? Did you grow through it? How did you stand up in your shoes? And what has that got to teach those coming after you? Because this is not just pretty stories, and it's not just to tell your story and leave your footprint. It's for your life to have meaning, your purpose to be passed on, as well as everything that you accumulated in material wealth. So how you go through the difficult times, what you're really proud of, your accomplishments, what you're grateful for, your hopes and blessings for those coming after you, and then just how you'd want to be remembered. And everything that I asked you to write, I give you little samples of those who've written them for. Just yesterday, I am in tears in my office because this lady whose husband has died relatively young had written a letter to their son, to their only son, and it would have taken a tear from a rock. And he was saying, I hope you never have to read this, because he wasn't anticipating death. But he said, if you're reading this, something has happened to me. And he went on to tell his son how much he cared about him. And while he didn't write a letter to his wife, he kept telling his son how lucky they both were to have her. So it was really a testament to her also. And that letter is so valuable. So I think this is as valuable as leaving the assets. And so I give you lots of little samples, and that lady yesterday gave me that copy of the letter and gave me permission to use it. So it will find its way into my legacy letter gallery. So I think we have a wee raffle today, James, is that correct? And we are almost done. So maybe when you wrap up, you could ask Christina if we have a wee raffle, because I believe we have.
We do.
And this will be one of these will be included.
Can I take the book, or should I just?
Oh,
I see.
no, that's grand. That's grand.
Okay.
So that's it, that's the second thing, is writing the legacy letter.
I have a question about power of attorney.
Mm-hmm.
So I have, and you did it for me and I appreciate it very much, my power of attorney for financial
Mm-hmm.
and named my son.
Mm-hmm.
Now, does something happen like when he marries? Is there, somebody said to me, oh, you better be careful because his wife could, take everything, or she could, if they divorce or something, anything that you would have had for him, she can take it from him?
So how did you do a will?
Just the power of attorney.
So the power of attorney is only about your lifetime. It's only while you're here unless able, either lost capacity or so infirm that you're not going to the bank. So it would be either by beneficiary designation, you leave everything you have to your son or your children, as well as maybe through a trust. And when we trust plan, one of the really nice things about assets going through a trust is that they're for your son's benefit, but they're not his. So while it's in trust, it's for his benefit. He can take anything out of it that he wants, but while it's in the trust, it ties back to you, not to him, will never be subject to a divorce settlement. So that's one of the reasons, honestly, our wealthy families, the money never comes out of trust, because it's never going to be subject to any kind of a divorce settlement or a creditor. The money while it's in trust. Now, it doesn't mean that it's tied up for them. They have access to it, but anything, when they're not using it, it's growing and it is protected in a trust. All right.
Nice.
Any other questions? Any thoughts?
I had a few questions, but I'll ask it in private.
I actually had one. So this is interesting. So the trust, it covers all 50 states. Meaning that,
Yeah, if we do a revocable living trust,
Right.
yeah, it's subject to our uniform trust code,
code
which is all states.
encompasses all
Yeah,
states.
yeah, we're all party to the uniform. So we each have our own trust code, and then we've all signed up for, virtually is the best one way of putting it, for a uniform trust code. So and you can choose the situs and you can move the situs. You could do your trust in Illinois while all your property is here, and then you move to Florida, you move to the vacation home for your retirement, and you can just move the situs of the trust to there. So that's
so you
a
have that
huge advantage.
flexibility.
Yeah, to that
it's
kind of a
huge
trust.
flexibility.
I remembered a question. If you are selling your primary home or rental real estate or stuff, so you're constantly kind of in flux with what you own, do you have to update the trust with those sale of your primary home and purchasing a new primary home?
No. So when you set up the trust, the very first time that we're putting your home in, yes, we have to take it from you to the trust. But if you're selling it, you'll sell it directly out of the trust and you'll take your new one directly in. So you would just let your realtor,
Okay.
your attorney, the title company know that you already have a trust. If you planned with me, you'd have a little certification of the trust, so you wouldn't have to carry around your binder. You just say, oh, I have a trust, here's how to name it, and they'll just take your new property into the trust. So you won't have to do that little skippity again.
Okay.
Just keep in mind that you have the trust and it'll come right into it.
I'd like to piggyback on her question. So does that also mean for people that move their accounts from bank to bank? Do they have to update the trust with the different banks, or they just, when they open a new one, they put in the trust name and it follows?
That's it. So however you had the trust lined up with that asset, you do it with the next one. So if we're hopping around a lot with CDs now because, we're getting better rates finally, and we might move it to, when it matures, to a different bank. So that if you had the trust as the beneficiary of the CD, then you just do the same thing at the next. If the trust is owning your CD, then the trust just owns your CD. So the nice thing about that is, some of our families don't necessarily, have, one or two children that they're leaving everything to, and that's a fairly simplified pattern. Some people who don't have children maybe do have a pet trust, and then they have a series of charities, and then they have nieces, nephews, godchildren, things like that. You don't want to be trying to fit that into a beneficiary form with your insurance or with your 401. So when you get all of that into your trust, then all you ever have to do is name your trust. And if you want to make a change, you come change the trust. Can you imagine if it took you forever to put 15 beneficiaries and now you wanna make a change because somebody's out or somebody new is in? You change it in the one place, your one trust, your grand central station. You don't have to change it at the bank.
Okay.
So, I mean, getting a trust in place, certainly cost involved, but there's also time involved. And that's a really, there's time and a little bit of cumbersome paperwork and getting in the trenches. So when I meet with you, if you want to do a trust, not only will I say, here's what your investment of your money will be, but I need you to invest some time in this too. It's a collaboration to get the trust lined up with the assets, but it's every bit as important as getting the trust done in the first place. Because if you have a beneficiary and you have a trust, the beneficiary, and you've never changed it, it'll remain who that is. We've got to make sure the trust is lined up with what you have.
Okay.
Why do some of the banks here in Illinois not accept your certification one-page?
Are we talking about Chase by any chance?
That's one of them.
Chase is certainly, they are bane of our life.
Yeah, but I think Fifth Third is another one.
Some banks just want everything.
Yeah.
And they say, it's might is right. It says right there in that certificate, this, and everything they would want to know about a trust, it's on that certificate.
Yeah.
And we tell them that the trust document declares that they don't need to see it,
Yeah.
but some banks just want it.
Okay, so you just give it to them.
Oh, or move our money.
Yeah.
But especially with the really bigger banks like Chase. Chase is one that it's their way of the highway, and they don't care even about our millions. The local bank cared enough about your business, your patronage, that, they would use a little bit of discretion, but I think, some of the bigger banks, it's Chase text boxes, and there's just no way around them. And if we want the whole trust, as I say, we either give it to them or say, fine, we'll just take it somewhere else. Yeah,
Okay.
yeah.
All right.
Okay, all right then, I think that wraps us up. Do we have James, would you mind going and see if we let Christine know that we are ready for our raffle?
Okay.